Good afternoon. My name is Amanda Rivera. I'm the hearing examiner presiding over today's case. The date is October 10th, 2025, and this is case SEZ2025-00001. It is a special exception request for an agritourism operation to get consumption on premises approval. Because this is a quasi-judicial hearing, all evidence and testimony must be taken under oath. So if you intend to speak, if you could please raise your hand. Do you swear or affirm the testimony you will provide is the truth?
I do.
Okay, thank you. Do we have members of the public here today? Yes? Okay. So the way that we'll go through things is first we're going to hear from the applicant. They're going to present their request in the case and call any witnesses that they may have. Following that, we will hear from the county staff who will present their recommendation in the case. They are recommending approval with conditions. Following that, we will go to public comment. So I'll call forward the cards that I have in the order that I have them. There is only one opportunity to speak, so I would encourage you to take notes as we go through things to make the most of the time that you have at the podium. After that, we'll come back to the applicant and the staff for their rebuttal and any closing comments that they may have. So with that, we can begin whenever the applicant is ready.
Thank you.
Good afternoon.
Good afternoon, Madam Hearing Examiner. So, for the record, Gabriel Arbois with the firm of Hahn, Mosier and Parks. I represent the applicant, JJ Days Holdings LLC. They are the owners and operators of the East Fork Creek Farm. Mr. Bartley is one of the principals of the company. He's here today. You'll be hearing from him later this afternoon. Also with me is Patrick Murray and Alexis Crespo of RVI Planning. You will hear from them as well. They've been in charge of all the planning in this case. And I apologize for my partner, Michael Witt, not being available today. He's had to deal with some personal matters, so I'm stepping in. So this is for East Fork Creek Farm. It's roughly a 10-acre parcel off of Hendry Creek Road. It's just west of US 41. It is bisected by that East Fork of Hendry Creek. What we're seeking is an exception in the AG2 zoning district pursuant to LDC for consumption on premises of alcoholic beverages through a caterer's license, 13CT, and a 4COP license in conjunction with an agritourism activity. East Fork Creek Farm, it's an idyllic location. The Bartleys have been operating it as an agritourism activity for several years at this point. They've invested a very large sum into this property, lots of effort. They've weathered through 2 hurricanes at this point. So this is a very, very important case for them. And this COP license is essential to their ability to continue with their agritourism activity. So you'll be hearing from Mr. Bartley on what their vision of the property is and how important this license is for them. It's specifically for consumption on premises for 2 structures on the property, an open air pole barn and a fully enclosed event center. You may recall that last time we were in front of you, about 6 weeks ago, there was an error in the public notice. It failed to indicate that we were seeking a 4COP license. We're now back before you. The conditions that were recommended by the county last go around in their staff report, we were in agreement with. They were consistent with our application. But since that time, and there's been no indication why, there are some changes in those conditions. And we specifically object to 2 of those conditions, in particular, condition 4B, which is regarding the relocation of the 6-foot opaque walls off of the northern and western boundaries of the property in order to allow the installation of a type A buffer. That was not in the staff report last go around, excuse me. And condition 5, which is regarding the hours of operation. The last time we were in front of you, the hours of operation were to be from 12 p.m. to 10 p.m. on the weekdays and Saturday, and then on Sunday, 12 p.m. to 9 p.m. We were in agreement with that. We were fine with that. That, in addition to many of the other conditions, which you'll hear about today, were intended to minimize the impact of any noise caused by the new use. And so we object to those two conditions. They weren't in the report 6 weeks ago. There's no stated basis for why they were changed during that interim 6 weeks. It's not stated in the staff report. We've not gotten a meaningful explanation on why those have been added.
And I can ask this question as we go
Sure.
through, but I'm guessing the reason is because the request changed slightly, right? It sounded like you were adding 2 COP or 4 COP, and there was some discussion about that. It seems like now all of them are kind of in the bucket of the request, and you're just broadly saying consumption on premises in whatever form that may take. But typically, as you know, the 4 COP would be a restaurant use, which is much higher frequency use than what a caterer's event would be, right? Because a caterer's, it's planned, it's usually on the weekends, or it's a more targeted event. So I'm guessing that's where that's coming from. So does your objection still stand if that's the intended use, or do you know what the intended use is going to be at this point?
We 100% maintain the objection. That is not the intended use, and we've been abundantly clear about that since the beginning of this application. Throughout the application process, we've confirmed to the county that this is not intended to be a daily commercial use. This is not intended to be a restaurant. The 2 COP and 4 COP is merely to help facilitate their ability and have flexibility in organizing these events, whether it's a caterer or whether it's through the property owner. They've partnered with a catering company, G3 Catering, and they have the exclusive right to serve food and beverage on the property. So not intended to be a daily commercial use, not intended to be a restaurant. And I would also point out that I don't think that's much of a distinction between what was proposed before and what's proposed now. It was a 13 CT, 2 COP, serving food and beverage and alcohol through a catering company. What is the significant difference with the owner holding that license when the use ultimately is going to be exactly the same? But be that...
That process with DBPR, I assume that's who still does the licensing for the alcohol issues. Has that been started? Have you identified with that agency which permit you're going to be pursuing?
I don't believe that's been commenced. No, it has not. And really what the purpose of us getting the 2 COP and 4 COP, again, is in order for us to have flexibility in how we plan out how to use this property. If we don't get a 4 COP, we'll get a 2 COP. It's really just to protect the property owner and be able to have that flexibility. So there's been no significant change. There's no stated basis for the new conditions. It really doesn't make sense why we would be restricted in this way when Lee County's own noise ordinances allow sound until 10 p.m. This is inconsistent with that. And we've already had conditions and agreed to conditions to minimize the impact of any amplified sound. There's going to be no amplified sound whatsoever in the open air pole barn. If there is amplified sound, we're required to keep the event center fully enclosed. That event center is the only site where amplified sound will be used. All the windows need to be shut, and all the speakers within the event center need to be directed towards the north or the east of the property in order to not direct sound towards the adjacent property owners. So we believe the limitations on hours of operation is unjustified. It's highly prejudicial to my client and their ability to plan events, to have the flexibility for their proposed event center. So it's very, very important. And it's also not fair for my client to be limited to 9 p.m. when all the surrounding properties are allowed to go into 10 p.m. per the ordinances. Again, no stated basis for that. With respect to condition 4B, again, not included in their staff report 6 weeks ago. And also, there's no reason why we should be required to relocate the walls. The western wall is not on the property line. It's sufficiently back from that property line to allow for type A plantings. There's no need for us to relocate There's no reason why my client should be burdened with the expense of having to relocate a wall, which in and of itself is sufficient and far exceeds what's required under the code.
And I can ask that again too,
Sure.
but I did the site visit prior to the last hearing, and at that time, the wall only extended along the frontage of Hendry Creek Drive. Now it looks like it does go well beyond where the open air barn would be. What is if you can clarify for me, I got a little lost in what's the actual issue with that wall. So do they want it to be a higher wall or a closer wall somewhere to the property boundary?
It's a little bit ambiguous from the staff report, but as I understand, they would like us to move it back away from the property line in order to accommodate a type A buffer.
Okay.
That's my understanding.
What's been installed at this point? What buffer standards did you erect the wall? There are some plantings on the exterior of the wall. There just aren't very many, and they're new, obviously, but I'm just trying to figure out what standard was guiding that behavior since that occurred since the prior hearing.
I can't speak to that directly.
Okay, and we can address it later. You might be addressing it. Since you mentioned it, I wanted to get the question out.
Sure. So again, this has been a major investment for my client. They've already incurred significant expenses in bringing this property up to operation to build out the event center. And they've already installed that 6-foot wall. There's no reason why we need to go back and start moving things around when what's already existing is sufficient and far exceeds the code. And so based on that, based on what's in the record, based on the testimony you're going to hear today, we're confident that you'll make the correct decision and approve our application without that condition 4B and without those limitations on hours of operation that are proposed in condition 5. And with that, I will turn it over to Mr. Bartley.
Thank you. Good afternoon.
Good afternoon, and thank you for the opportunity to speak with you today. My name is David Bartley, and my wife Elise Bartley, who I've been married to for 35 years, who is unable to be here today, are the owners of EFC Farms, East Fork Creek Farm, located here in Fort Myers, Florida. We want to share with you not only what we do as a farm, but also who we are, our values, our vision for the community, and why EFC Farms is more than just a place where food is grown. EFC Farms was born out of a passion of sustainable farming and community wellness. After Hurricane Ian, when much of Southwest Florida was devastated and our farm was destroyed, we committed ourselves to rebuilding in a way that would not only provide fresh food for local chefs and the general public, but also serve as a model of resilience and innovation. We are an all-natural farm specializing in aquaponics, an advanced farming system that combines aquaculture, raising of fish, with hydroponics, the growing of plants and water. This creates a natural ecosystem where fish and plants sustain one another, using up to 90% less water than traditional farms and about 10% of the property a traditional farm would use. But EFC Farms is more than a growing system. We view our farm as a sanctuary for our land, our animals, and our people. We've worked intentionally to make it a place where community members can gather, learn, and see sustainable agriculture in action. At our farm, we have three main components. The food production. We produce nutrient-dense, chemical-free produce year-round. Our aquaponic greenhouses allow us to grow fresh lettuce and leafy greens consistently, regardless of the weather extremes we have here in Southwest Florida. Alongside our plants, we raise our tilapia fish. We have honeybees and have had other animals. We have hosted school field trips, farm tours for garden clubs, and educational events to show how food can be grown sustainably. Children and families have come to see firsthand the nitrification process, understanding the life cycle of plants and fish, and learn about responsible farming practices. We've also collaborated with local organizations to highlight the importance of healthy food in Southwest Florida. On our property, after Hurricane Ian destroyed several of our buildings, we designed and built the BEC. It's the Bartley Education Event Center. It's a beautiful climate-controlled building. It's our hope that this venue will host weddings, community events, educational opportunities, corporate gatherings, and create a space where celebration directly supports sustainable agriculture. The revenue generated will help sustain the farm, creating a farm-to-event model that blends agriculture with hospitality and agritourism. Our impact goes beyond just our crops or events. It's also about strengthening community resilience. We have food insecurity. By producing food locally, we help reduce the reliance on long supply chains that can be disrupted by storms or economic challenges. Through education, we've had hundreds of students and families visit our farm, walking away with a new appreciation for where food comes from and how it is grown. The local economy, the produce that we grow is sold to local chefs, and the events hosted at the BEC will bring people into Fort Myers, supporting small businesses, caterers, florists, and so many more. Environmental stewardship. Our aquaponics system conserves water, protects the soil, and creates a closed-loop ecosystem that minimizes waste. And finally, our community. Not if, but when, and thankfully, so far so good this year, the next hurricane occurs, we want this building to be a resource for our neighbors, as it has backup generators, air conditioning, a full commercial kitchen, a shower, washer, and dryer. At the heart of EFC Farms are our three guiding values: sustainability. Every decision we make considers the long-term impact from hurricane-resistant structures to chemically free growing practices. Community, we believe that the farming is about people, not just plants. Our farm is designed to welcome neighbors, schools, and families. Innovation, we embrace forward-thinking solutions, whether it's aquaponics, renewable energy integration, or new models of farm-to-event partnerships. When we purchased the farm property in 2021, we discovered that this property had been a farm since the 1950s. It was a nursery tree farm way before any housing development around it. The farm was totally destroyed by Hurricane Ian. We so believed in our vision and chose to rebuild, and we are still in that rebuilding process today. Farming is difficult in Southwest Florida, and despite our best efforts, our costs have exceeded our revenue. This is not sustainable. We need another revenue resource or source to allow our farm to be financially sustainable. The BEC, our new education and event center, along with the zoning variance that we are requesting to allow alcohol sales during our agritourism events, will make our farm sustainable. We see EFC Farms not only as a successful agricultural project, but as a blueprint for what's possible in Southwest Florida. Imagine more farms like ours, resilient to storms, conserving resources, feeding local families, and offering spaces where the community can gather. That's the vision we've been building toward, and it's the one we want to continue sharing with others. In closing, EFC Farms is not just a farm, it's a community resource, an educational hub, and a model for sustainable agriculture in our region. We want EFC Farms and the BEC to be the premier agritourism destination in Southwest Florida. We are proud of what we've built and excited about how we can continue to inspire others. Thank you for your time and consideration.
Patrick Murray will be speaking next.
Thank you.
Good afternoon, Madam Hearing Examiner. For the record, Patrick Murray with RVI Planning and Landscape Architecture, and I've previously been qualified as an expert witness by the Lee County Hearing Examiner. I'd like to present to you our presentation, a copy of our presentation, and then I also have a slightly revised 48-hour letter that highlights the grammatical error or change that we are seeking.
Okay, thank you. So the PowerPoint presentation will be applicant Exhibit 5. Thank you. We retained the numbering from the first hearing. And then the revised letter will be applicant Exhibit 6. Thank you. Is the substance of the revised letter any different than what I've already reviewed and received?
So our revision includes the specific word type A planting, type A buffer plantings, opposed to just type A buffer.
Okay, thank you.
To reiterate, the team is made up of Mr. and Mrs. Bartley from East Fork Creek Farm, Mr. Abreos, and myself and Alexis Crespo from RVI Planning. This request is a special exception request for consumption on premise of alcoholic beverages on an agricultural designated property subject to 13 CT, 2 COP, and 4 COP licenses. The subject property is located in a developed area of Lee County and is approximately 10 acres in size, south of Henry Creek Drive, 800 feet west of South Candy Trail, and the property does currently have agricultural exemption, and the uses that occur on the property include hydroponic, aquaponics, greenhouse, chicken, goats, and bee productions. The subject property's future land use is suburban with central urban to the east. The zoning category is AG2, agricultural, with residential properties to the east and commercial zoning districts to the, residential designations to the west and commercial to the east. This is an overall view of the concept plan, and it outlines that the property, and I'll have a more zoomed in location of the subject area that we're focusing on, but the entire property is 10 acres in size, and I look at it as essentially 8 acres in the south and 2 acres in the north. There is East Fork Creek that divides the two areas, and you'll notice on the 8 acres is the agricultural production with the greenhouse aquaponic production occurring. This is the area that we're discussing, is the consumption on premise is in the hatched, which is the pole barn on the western side, and then in the center area is the event space building. Subject property is accessed from Henry Creek Drive with 2 ingress and egress points. There is parking for 83 cars or spaces. And then you'll notice on the western boundary, we do include a type 5A buffer with 6-foot opaque wall, and then a 6-foot opaque wall that does go along Henry Creek Drive.
With regard to the parking, where did the number, how did you derive at 83 spaces? I noticed the utilities letter estimated 225 people, and there was some mention of 178 somewhere in the documents. I couldn't put my finger on it again from when I took my notes, but I'm just curious, on these events, how many folks are we actually accommodating, and is 83 spaces sufficient to accommodate that?
Yes, and this was through staff sufficiency and review. So we have approximately 8,763 square feet of usable area, which calculated to 87 spaces. Our 83 spaces are the designated striped areas, and then there are other areas throughout the property that could accommodate the remaining parking.
Okay, so if you have an event that's well attended beyond what the 83 spaces would accommodate. You can accommodate your own traffic or your own parking on your site without needing to overflow into the surrounding community?
Yes, that's correct.
Thank you.
And just to reiterate that the pole barn is 5,000 square feet, but approximately 4,500 square feet would be the area of consumption on premise. And likewise, the education center is approximately 2,500 square feet, and about 3,700 square feet would be the area where events would actually take place and the consumption on premise would occur. So in April, we did have a community meeting at the event center. It was attended approximately between 8 and 10 people, and we did send out notices to 500 feet radius. Through that discussion, it was more of a casual discussion than it was a presentation, which was quite nice. But we did come to a consensus on buffer types, opposed to doing a 6-foot opaque fence. Mr. Bartley agreed to doing a 6-foot opaque wall. Aesthetically, it's much nicer. And then also agreed to type A plantings along the western boundary, which is a residential property that we directly abut. Additionally, we landed on the hours of operation that coincide with the Lee County ordinance, noise ordinance. I'll address this. It's also in our 48-hour letter from Monday through Saturday, noon to 10 p.m., and then on Sundays from noon to 9 p.m. And then we also discussed noise and amplified music, and which we landed on that, okay, no amplified music would be within the pole barn, and that also the event center would be fully enclosed if there is amplified music. This is subject to a 13 CT, 4 COP, and 2 COP license. I just wanted to highlight that the 13 CT, which was our initial request where we were in the August 21st hearing, was beer, wine, and liquor. We've since modified that to allow flexibility, and the 4 COP also includes beer, wine, and liquor, along with the 2 COP, which would be limited to beer and wine. I'll note that the 4 COP does require alcoholic beverages to be served in simultaneously with food, and there is a 51.49% gross food sales requirement. Next few slides are a few images of the property as it is today. The one in the top left is looking west on Henry Creek Drive. The one on the bottom is looking east along Henry Creek Drive. And then internal to the site looking out with those nice plantings. And then on the eastern side, we have no buffer, but we have enhanced plantings as well. This is again looking at the eastern side where it is a vacant property. And then most recently, this is the western boundary along Roberts Lane. This is the type A plantings. This is the 6-foot wall, and it does include 4 trees per 100 feet, which is 16 trees. These are hollies. We anticipate that will grow, the canopy will grow above the 6-foot wall to provide additional buffer, and that they are adequately planted or professionally installed. This is the event center itself. Just think it's worth acknowledging the aesthetic of it. It's quite astonishing, and is the beautification of the actual building itself, and where it would be great to host events, which would only further promote the agricultural practices of Lee County. And then as far as the Lee plan and its consistency, the COP associated with agritourism is permitted non-residential use within the suburban future land use category, provides compatibility, maintaining the agricultural practices that currently exist on the property, promotes the agricultural use, and utilizes the land within an area that has existing infrastructure. As for the Land Development Code, as noted in the environmental report completed by staff, that it does have no impact to Henry Creek and will continue to operate as an agricultural production as it has since the 1950s as the Kelly Tree Farm.
Can you go back for a second? The bottom point on the slide about not being injurious to the neighborhood, conditions managing noise levels, lighting hours, and guests per event. I did not see all of those addressed. Is there a guest count limitation to the size of the events, and I just missed it?
We initially did propose that, and it was not included in the conditions.
Okay, what would the amount have been if that had been included?
And I can,
For serving in the facility, the maximum number of people would be 178.
Okay, that's the capacity of the indoor
Capacity
facility?
of the indoor facility.
Okay, that's where I saw 178 somewhere, so that's probably where that number came from. Thank you. And then the noise levels, obviously, and then the lighting, I guess, that's all combined under that live entertainment condition? It's kind of the catch-all? Okay, thank you.
as outlined in the 48-hour letter, we were in agreements with the August 21st staff report. We are requesting that the western property boundary abutting the COP area to include a 5-foot wide type A plantings with the 6-foot opaque wall, and that maintain the northern buffer with the 6-foot opaque wall along Henry Creek. And then additionally to the initial staff report from the August 21st hearing examiner staff report, that we maintain the hours of operation that were previously agreed upon. To conclude, the applicant is in agreement with the conditions as outlined in the 48-hour letter. Staff did recommend approval. The project is consistent with the Lee plan, is consistent with the Land Development Code, is compatible with the existing surrounding land use pattern, and further supports agritourism and agricultural uses.
I had one technical question before we get to staff. I made a note of at the first hearing. I need to put my hands on it. The 48-hour letter for the initial hearing, I believe you had submitted an updated site plan and had asked for that to be substituted. The staff report included 2 pages that were both in the site plan category. Did you want both pages to be updated?
I noticed that in the latest staff report, they did include the site plan from the April 14th, dated April 14th, and that was the one that was brought to discussion on August 21st.
So you want to use the August 21st 48-hour letter as the current site plan?
Correct, and that's the...
This page was also included. So are you intending both pages to be appended as the site plan?
Yes, and I'll note that page right there is the layout of the event center. It's not the entire site plan. That does not include the pole barn.
Okay, thank you. That's just a technical matter I want to be sure I take care of before we get to staff. Thank you.
Thank you.
If staff's ready. Good afternoon.
Good afternoon, Madam Hearing Examiner. For the record, my name is Cam Mohammed. I am a zoning planner with the zoning section of Lee County's Development of Community Plan. This afternoon, we are hearing Special Exception 2025-1 for the East Creek Fork Farm, or the East Fork Creek Farm. COP request. The applicant is requesting a special exception to allow on-premise consumption of alcoholic beverages subject to the following licenses: 13 CT, 2 COP, and 4 COP, as I defined in the staff report, SFS license specifically, in conjunction with the agritourism activities as proposed by the applicant. The property's information, the property is located at 6901 Hendrick Creek Drive, is approximately 10 acres, located in the suburban future land use category, and is currently zoned agricultural AG2. The parcel's history. The subject property is zoned AG2 and is currently utilized for agricultural purposes as evidenced by an existing agricultural exemption from the Lee County Property Appraiser. These images depict the current future land use as well as the current zoning. The zoning of the surrounding properties. To the north of the subject property is agriculturally zoned parcels. To the south are additional agriculturally zoned parcels. To the east are agriculturally zoned parcels. Further east, abutting South Tamiami Trail, are commercially zoned parcels. And to the west, immediately, are agricultural parcels, as well further west, residential parcels. This case is reviewed under the criteria held in LDC Section 34-145, specific to special exception requests. LDC Section 34-145C establishes the review criteria, and I will go through the remainder of this presentation detailing just how this request meets these criteria. Special exception review criteria, letter A. Is this request consistent with the goals, objective, policies, and intent of the Lee Plan? The analysis of the compliance with the Lee Plan will be discussed in the following slides of this presentation. Agritourism explained. As the applicant has mentioned, this COP request is in conjunction with an agritourism activity. Per Land Development Code Section 34.2, agritourism means any agriculturally related activity on land classified as agricultural under Florida State Statute 193-461 that is consistent with and accessory to a bona fide farm or ranch or in a working forest, which allows members of the general public for recreational, entertainment, or educational purposes to view or enjoy activities including farming, ranching, historical, cultural, civic, ceremonial, training, and exhibition, or harvest your own activities and attractions. Land Development Code allowance under Ordinance 15-11 which amended the Land Development Code Section 34-653 to allow agritourism uses within the AG2 agriculturally zoned districts and establishes supplemental regulations governing agritourism. These uses include passive and active recreational activities, educational activities and classes, demonstrations, events, and tours, produce stands and sales of unprocessed and processed agricultural products, agriculture-related crafts, cottage food products as defined by Florida state statutes, food and beverage service, limited as defined, and other activities determined to be substantially similar to the above-mentioned activities. Lee Plan. The parcel is located within the suburban future land use category and consists that suburban future land use category consists primarily of predominantly residential areas that are either on the fringe of the central urban or urban community future land use categories or in areas where it is appropriate to protect existing or emerging residential neighborhoods. Lee Plan for Water and Sewer, Standard 4.1.1 and Standard 4.1.2 have been addressed as the applicant has provided a letter of availability from Lee County Utilities indicating infrastructure and capacity is available to serve the subject property. So fulfilling those standards, all requirements of the standards of the Lee Plan and LDC will be met at the time of development order as stated by the applicant. Policy 5.1.5, residential land uses. This policy exists to protect existing and future residential areas from any encroachment of uses that are potentially destructive to the character and integrity of the residential environment. If such uses are proposed in the form of a planned development or special exception. If such uses are proposed in the form of a planned development or special exception and generally applicable development regulations are deemed to be inadequate, Conditions will be attached to minimize or eliminate the potential impacts, or where no adequate conditions can be devised, the application will be denied altogether. A special exception is being sought in this case, and any applicable conditions may be attached to minimize or eliminate any potential negative impacts to the surrounding community. The proposed use is permitted in the underlying AG2 zoning district. The Land Development Code Section 34-1264A2A requires a special exception to permit the sale or service of alcoholic beverages for consumption on premises in conjunction with limited food and beverage accessory to an agritourism activity when located within 500 feet of a dwelling unit under separate ownership. The applicant has provided a site plan depicting proposed COP areas, which are limited to the northern 2 acres of the site, approximately 1,100 feet away from Devonwood Estates to the west, and proximate to Hendry Creek Drive and the US 41 commercial corridor, as indicated on the site plan. The property includes 5-foot wide buffers in addition to opaque walls and landscaping where the property abuts residential lots. Staff has included additional conditions related to the hours of operation and noise considerations to assure compliance with this policy.
So on that point, is it your position then, I assume you still maintain that you want these conditions in with the enhanced buffering and the relocation of the wall? So did you make a finding that 5.1.5 was not met without the conditions that you proposed?
Yes.
Specifically?
Yes.
Okay, so when you're saying that they meet it, you're saying they meet it if they comply
Exactly
with
that.
these deviations that have been included?
Yes, ma'am.
Absent that, you would have a finding that they have not been consistent with 5.1.5? Okay. And what is the so I know you gave me the footage between this and Devonwood, which is to the south, but that western property that's right along whatever that road is, the county maintained road, do you know what the distance is to the nearest residence
I do not.
overall from the two? Okay, that's a question I can ask of the applicant as well, just if they know. It's obviously close. Just doing the site visit, you've got the folks that are north of Hendry Creek Drive, and then you've got the folks that are to the west of, again, whatever that local road is. And so
Roberts Lane.
that's gonna be closer to the 2 acres that we're talking about, because the Devonwood folks are separated
By that agricultural part.
exactly by like the last 8 acres essentially of what they've got going on in the back. Okay, and will you be talking more about the conditions? Is that later in the presentation?
A bit later, yes.
Okay, then I will hold questions for then. Thank you.
Policy 9.1, agricultural land uses. The subject property is an existing agricultural use on agriculturally zoned property with an active agricultural exemption from the property appraiser's office. The property is not located in the agricultural overlay, but is in a future suburban area of the county. Policy 9.2, the subject property is an existing agricultural use in an area comprised of existing residential uses, agricultural uses along Hendry Creek Drive, and commercial uses along South Tamiami Trail to the east, emphasizing the diverse land uses within the existing neighborhood. Agricultural land use is continued. Policy 9.2.1. The subject property is not proposing a rezoning to the agricultural zoning district. The property exists as agriculturally zoned in the suburban future land use category. Special exception review criteria continued. This criteria requires that any proposed special exception will protect, conserve, or preserve environmentally critical and sensitive areas and natural resources where applicable. The special exception site plan does not propose any impact to Hendry Creek or impact environmentally sensitive areas of the site. Special exception review criteria C will be compatible with existing and planned uses in the surrounding area. The applicant intends on continuing to maintain and operate the property's current use as an agricultural farm. The proposed special exception use will occur on a limited basis and, as conditioned, will remain compatible with the surrounding land use pattern. Landscape buffers, as conditioned, will screen the views of the event space housing COP along the western and northern property lines. This includes a 6-foot tall opaque precast wall as approved through the fence permit FNC 2024-03232. Buffers. To the north, the existing use is the right-of-way, Hendry Creek Drive. The required buffer, or as staff recommends, a type A buffer to ensure compatibility with the existing residential neighborhood. South is also a right-of-way. There are no required buffers to the south. West, the property abuts existing single-family residential uses zoned AG2. The applicant and staff both recommended a type A buffer to ensure compatibility. To the east is an undeveloped AG2 zoned parcel, and there are no required buffers to the east.
Are they meeting the type A buffer to the north?
That's part of the condition that's been,
Okay, so the fence permit that's referenced, it runs the entirety of the wall, which was north and west. Okay, thank you.
review criteria letter D, will not be injurious to the neighborhood or detrimental to the public welfare. The applicant is proposing limitations to the agritourism use so as to not impact the surrounding residential uses. This includes proper management of noise levels, lighting, hours of operations, and numbers of guests per event. Staff has proposed conditions of approval to ensure compatibility.
And on the issue of the numbers, was the 178 number evaluated by staff and agreed to, and that condition just got omitted by some reason?
It wasn't much review based on the total number. It was more so the overall use that was looked at.
That last slide that you had included, just as they did, the number of guests, and so I'm just curious where that, because the finding is that it's compatible as conditioned, but there is no condition that caps the guest count. So I'm trying to get to whether that's a requirement to continue to find compatibility.
So based on what's in the land development code, that's something that's allowed to be limited. It was not limited specifically.
So staff did not evaluate a particular guest count
No,
in
ma'am.
its conditioning. Okay.
Special exception review criteria letter E. This request must be in compliance with zoning regulations pertaining to the use and other applicable regulations. The request allows the applicant to promote the primary use of the property as an aquaponics/hydroponic farming activity. The request for special exception is in compliance with zoning regulations pertaining to the uses and will occur on a limited basis.
To that point as well, on similar cases that we've had with agritourism operations that have COP, there's typically a condition that just requires maintenance of the agricultural exemption. The code already requires that under the ordinance that you cited that was codified into the LDC, but was a condition of that nature reviewed or suggested at any point?
Was not reviewed. So the current conditions as proposed by staff, site plan development of the site must be substantially consistent with the site plan reviewed or revised April 14th, 2025, attached as attachment G to the staff report. COP is limited to the areas depicted on the site plan. Special exception approval. Special exception approval does not establish a right to obtain permits from state or federal agencies. Further approval does not establish county liability if the applicant does not obtain requisite approvals or fulfill obligations imposed by state or federal agencies, or undertakes actions that result in a violation of state or federal laws. Condition 3, COP license. Consumption on premises is limited to either of the following: 13 CT, 2 COP, or 4 COP SFS licenses in conjunction with limited food and beverage services as an accessory to the agritourism activity. Any change in use for these license types will require separate approval in accordance with the LDC.
What's the significance of the SFS?
That specifies 49% to 51% food and beverage sales.
Is
or
there a 4
food
COP
sales.
that does not have that SFS?
It's detailed in the staff report. I kind of like broke down all of the
Right.
different requested licenses. I kind of just left it as
So
to
did
what was
Staff,
requested.
and I'm asking again, it's the conditions are what they're going to be held to. So if, I know they were discussed, but the condition that you landed on was the 4 COP SFS. So I'm trying to determine if a 4 COP in general is what they've requested, if that was found to be not recommended or not compatible, and it's only if it's a 4 COP SFS?
So during conversation with the applicant, I was informed that SFS was what was being sought. So I went based on what I was told.
Did applicant agree with that? with
Yes, that is
condition?
correct. And the difference between the 4 COP SFS and the 4 COP quota is primarily the quota is more associated with package stores and
A bar and cocktail lounge
Correct.
typically is where you see that, right? It gets dicey here, and I know I'm getting very specific, but because you guys are falling within an agritourism operation, as everybody I'm sure is well aware, a lot of uses that would not typically be permitted in these kinds of districts, like an ag district, are permitted because you fall under that umbrella. And the only foothold that the local government really has in this context is offsite impacts. So that's where we're really trying to get to, and that's why I was saying a restaurant, bar, lounge clearly operates much differently than a catered event where you're having them, once a month, twice a month, whatever that number might be. So I'm asking my questions with that lens on of just what protections are we putting in place for the community, and once those are done, you're going to be able to operate with a lot of latitude based on how the statutes are phrased and what the local government can actually regulate. So I just want to be sure that staff recommended what they recommended based on those findings of compliance with an eye towards that as well.
Yeah.
Thank you.
Condition 4, specific to the development order and permitting requirements. Prior to any sign-off of state alcoholic beverage licensing documents by Lee County, the applicant must amend or pursue a minor change to the LDO that was approved to demonstrate compliance with the following conditions. A calculation of the total impervious surfaces, a 5-foot wide enhanced type A buffer to include a 6-foot tall opaque wall landscaped on the exterior side of the wall with 4 trees planted per 100 linear feet, must be depicted along the western property boundary abutting the COP area and along the northern property line abutting Hendry Creek Drive. Condition B, or 4B, fence permit FNC 2024-03232 must be revised to relocate the 6-foot wall off the western and northern property lines to allow for the planting of the required type A buffer trees along the western boundary abutting the COP area and northern property line along Hendry Creek Drive.
Okay, so can you detail for me again, why is what they've done not consistent, or why is what they have done not be suitable under 5.1.5 for a finding there?
So essentially what's been done to the western property line needs to be mirrored along the northern property line. And that conclusion was, we've arrived at that conclusion based on the types of uses. So the similar uses along the western property line are what are occurring across Hendry Creek to the north.
Okay, so you're not, that was something I was not understanding from the document. So you're not saying that they need to relocate the entirety of the western boundary. The western you're okay with?
Right, I just need those
Only the, okay.
plantings to be there.
And the wall, the issue is with the wall on the northern is that you're saying there's not sufficient space for them to meet the type A planting material
Yes.
requirements that they have in the distance. So they would need to set it back further to provide that.
Exactly that. And that's where the modifications or any types of revisions that may be necessary are mentioned, because those permits have already been issued and site improvements most likely have already occurred. So to have that revision completed would then allow for those plantings to be placed.
Is there any way for them to meet the spirit of the code without relocating the wall? Because the issue they're going to have is the wall is already there on the western boundary, and if that's sufficient, and to remove the northern one, that's going to mess up. I'm not sure exactly, the geometry essentially of where that connection is occurring. So it's not as simple like just pick up and move it kind of
Right.
direction to
Definitely
them.
isn't.
So we make allowances a lot of times when the spirit of the code can be met, even if a strict application of the code can't. So would there be enhanced screening that they could do, or more plantings that they could do of lesser nature that would meet the same protections? Because it is slightly different, because you do have Hendry Creek Drive, which is a much larger and more traveled road than what you've got along the western side, right? So was that considered at all, or it was just a strict application of the code?
It was pretty much a letter of the law idea. There was not much review for any potential of other ways for this to be addressed. Would you like to speak to that?
I mean, I think the code says that the minimum planting area has to be 5 feet, and I'm not sure what the planting distance is in that area, so I don't know what that would create for the applicant or for the project. Yeah.
And we may just depending on where this goes, I need to hear from the public and get back to this as well. But just in terms of where my mind is at, if we can meet that with some other agreed upon manner, maybe that's something that we can leave the record open for you to have those discussions. And if at the end of the day, the answer is no, you can notify me of that and I will make the decision based on what I have before me. But if we can provide additional protections to the neighbors, I would like to do that. Also recognizing that what's there is there. And that wall along the north was there when I did the site visit back in August. So the addition of the western wall is new, but that was already there. So if that permit was issued, I do see where there is some hardship, might not be the right word, but some concern that they might have, that it's not a simple task of just, you know, moving something that might be a plant or a tree that's a little less mobile than what we've got with the wall.
Understood.
Okay, you can continue. Thank you.
Condition 5, hours of operation. Events are limited to Sunday through Thursday, 12 p.m. to 9 p.m., and Friday through 12 p.m. to 10 p.m. Staff has recommended this condition to maintain the harmony of the existing residential neighborhood. Condition 6, live entertainment. Music and live entertainment are subject to the Lee County Noise Ordinance. Amplified music is prohibited in the open-air pole barn and is limited to only within the fully enclosed building labeled event space on the special exception site plan. All windows must be shut during events with amplified noise. Speakers within the enclosed event building must be oriented to the north and east.
So going back to number 5, what was the reasoning to change the hours of operation between the two hearing dates?
Essentially, just to maintain as much harmony, or just to protect the overall existing neighborhood. That was a discussion I had with supervisor, and that ultimately was the recommendation that came out of that conversation.
So the additional hour, because it sounds like, and I did not review the entirety of the staff report from the first case since it was revised in its entirety for this case. I didn't want to get the two muddled and be current with what we're asking, but the testimony has been that that was a change from the first zoning when staff agreed to the 10 p.m. for the majority of the days that we're talking about. So was it something in the request that changed it to 9 p.m. or it was simply that you had more time to think about it? I got
a longer time frame to review. We felt as if that would be something that would be able to be explained to be less injurious to the overall neighborhood.
Okay, thank you.
That is the conclusion of my presentation.
Okay. Thank you. Did applicant have any questions of the staff?
I do have one question. I just want some clarification on that last point. Am I to understand that the county, the basis for the change in the hours of operation is based on having additional time to review the application?
Not necessarily that would be not said as the sole reason, but the overall idea was making sure that this new request, including additional COP requests or licensing, would maintain a very small impact on the overall neighborhood. So I felt as if shortening an hour and then maintaining those hours for the weekend operation was in our best interest.
Is it the county's position that the proposed use is a restaurant use?
By the information provided from the applicant, we reviewed it as 4COP SFS, which would then equate to similar restaurant uses that also have that specific license.
Is that stated in your staff report?
It's defined by the license types. So 4COP quota is included as well as 4COP SFS.
And why was that? Strike that. Is it the county's position that the proposed use and its interpretation of it being a possible restaurant use, is that the basis for imposing the new limitations on hours of operation?
By requesting a potential 4COP SFS license, we had to review it based on the license. So whatever that license would allow you to do is what we felt the conditions would address.
Are you aware that the event center is not designed to be operated as a restaurant?
That's based on the floor plan. I can tell that, but based on what's been requested and the license that you would receive, once you acquire that license, then you're able to do whatever the functions of that license would allow you. We're able to set limitations as to what is actually done.
Do you know who on staff proposed this new condition?
It was a collaboration between myself and the zoning manager.
Do you just happen to know, as a question, did you look at any of the other COPs for special exceptions on the hours of operation, just for consistency, to see if, I would guess they impose them, typically we do, on a COP, just to see if there was any consistency among those and what the hours were?
That wasn't a part of the review process.
Okay, okay, thank
So
you.
this was a little bit more particular to what was being requested. So.
Thank you. Okay, so with that, I will open up the public comment period, and I'll call the cards in the order that I have them. So the first one is for Graham Belger. Good afternoon, sir.
Good afternoon, how are you? My name is Graham Belger. I live basically right across the street from this on Hendry Creek Drive, 6990 Hendry Creek Drive. The letter I'm reading here is from one of our other neighbors that lives down the road. He couldn't make it here today. He was at the previous meeting. So I'm just going to read this for him. His name is David Ciccarello. I'm reading this in his, as if he was reading it. My name is David Ciccarello, and I live in the same neighborhood where the property which is the subject of the hearing is located. My address is 15499 Thorey Court, Fort Myers, Florida, 33908. Unfortunately, I cannot attend the hearing scheduled for October 10th as I am out of town. I did attend the previously scheduled hearing and submitted a request to speak at that time. I am requesting that Graham Belger be permitted to read this statement in my absence, and if possible, that this statement be admitted into evidence for the hearing examiner's consideration. I am an attorney licensed to practice law in the state of Florida and have been practicing in Lee County, Florida since 2009. In fact, I am well acquainted with counsel for the applicant, Mr. Witt. Prior to this hearing, I received a voicemail message from Mr. Witt asking me if I would be attending the hearing on behalf of my client who also lives in the neighborhood. To avoid any confusion, I am not acting as a legal counsel to any of the residents of the neighborhood other than myself, my wife, and my 2 young children. In preparation for this hearing, I researched the law applicable to a request for a special exception such as the one under consideration today. Under Florida's Land Development Code, it is the applicant seeking the special exception who bears the burden of proof to demonstrate the special exception requested meets the specific requirements of the Land Development Code. This includes, in pertinent part, the following. 1. The applicant must show that the special exception is consistent with the goals, objectives, policies, and intent of the Lee Plan. 2. The applicant must show that the special exception will be compatible with existing and planned uses. And finally, 3. The variance cannot be detrimental to the public welfare or the character of the neighborhood. In addition, policy 515 of the Lee Plan is as follows: to protect existing and future residential areas from any encroachment of uses that are potentially destructive to the character and integrity of the residential environment. This is the law that the hearing examiner must follow in making her decision today. Make no mistake, the subject property is located well within the single-family neighborhood in which I live. In fact, there are single-family homes located contiguously on all 4 sides of this property. 3 on the east side in the single-family neighborhood of Devonwood, 3 on the south side, also in the Devonwood neighborhood, 7 on the west side, 5 of which are in Devonwood, and 2 of which are in my single-family neighborhood of Hendry Creek, and at least 2 on the north side of the property in my neighborhood. We drive by this property every day to take my kids to school. We walk our dogs past this property, and my kids ride their bikes by this property. At the end of our neighborhood, where Hendry Creek Drive ends at US 41, there are properties that are used for commercial purposes. This is not one of those properties. Those properties sit directly on US 41, and the people that access those properties do not go past those properties into the single-family neighborhood behind them. Those properties do not sell alcohol at all. This property is located in the residential neighborhood well beyond those properties. In fact, there are at least 4 single-family residences between this property and those properties which are located directly on US 41. The subject property is currently zoned for agricultural use and, consistent with its zoning classifications, is currently being operated as a farm. The agricultural zoning designation does not permit the applicants to sell alcohol at their property under a 4 COP license, and for good, sound policy reasons. The applicants have not shown and cannot show that the special exception is consistent with the goals, objectives, policies, and intent of the Lee Plan. Specifically, Policy 515 of the Lee Plan, which is to protect existing and future residential areas from any encroachment of uses that are potentially destructive to the character and integrity of the residential environment. The applicants have failed to present evidence that this special exception would have a positive impact or even a neutral impact on the surrounding neighborhood. The fact is, the special exception can only have a negative impact. A negative impact to the safety of the neighborhood, the traffic within the neighborhood, and the noise within the neighborhood. The applicants have attempted to argue that they would incorporate measures or conditions to minimize these impacts. However, their conditions do not eliminate these increased burdens on the neighborhood. 1 day a week is still more day a week than my kids cannot safely ride their bikes on the streets of my neighborhood. For this reason alone, the requested special exception should be denied. The applicants have not shown and cannot show that the special exception will be compatible with existing and planned uses. On this point, their application simply states, the proposed special exception use will occur on a limited basis as conditioned, will remain compatible with the surrounding land use pattern. Landscape buffers will screen the views of the event space housing COP along and western property line. This includes a 6-foot tall opaque precast wall as approved through FNC 2024-03232. Simply stating that the special exception use will remain compatible with the surrounding land use pattern does not make it so. The applicants do not offer any evidence that the special exception is compatible with the surrounding use pattern, that of a single-family residential neighborhood. That is because the sale of alcohol is inherently not compatible within a single-family residential neighborhood, fence or no fence. Therefore, the applicants have failed to meet their burden of proof on this point as well. Finally, to say that the special exception will be detrimental to the character of the neighborhood would be an understatement. Our neighborhood does not currently have an establishment located within its boundaries that is selling or serving alcohol to the public. In the event one is permitted to do so, it will most definitely degrade the character of our neighborhood. It's simply not possible to argue otherwise. Thank you for your time and attention. Sincerely, David Ciccarello. And then just on my behalf, like I said, we live right across the street. We have 2 small kids, and it is going to affect us. It's right there. Whether I love the fact that the farming and all that kind of stuff is really cool, and that's good. But the nighttime thing and serving alcohol, and especially weeknights till 10 o'clock, it's just for a residential neighborhood, it's a little over the top in my opinion. And I guess that's all I have.
Thank you. Thank you for coming today.
Thank you.
Thank you. The next card that I have is for Megan Belger. Good afternoon.
Good afternoon. My name is Megan Belger, and I live at 6990 Hendry Creek Drive. I'm northwest of the property, and we are less than 50 feet from their property line. I'm here today as a concerned resident and parent to express my strong opposition to granting this request. Our neighborhood is a quiet, family-oriented community where children play outside and families walk and bike daily. Allowing alcohol sales and consumption this close to our homes would create serious safety and quality of life concerns. We worry deeply about intoxicated individuals driving through leaving onto our residential street. Hendry Creek Drive is not designed to handle that kind of traffic or activity, and it would introduce unnecessary risk to our families, especially our 2 small children. We are also very concerned about the noise that would come from gatherings or events held on that property if alcohol is permitted. Even moderate outdoor activity, music, talking, and vehicles coming and going will carry directly into our homes and yards. At only 50 feet away, there is simply no effective buffer for sound. What might be an enjoyable night out for patrons could become a nightly disturbance for my family. Our community values peace, safety, and family life. A liquor license this close to residential properties would threaten all 3. We are not against local business or responsible development. We simply believe this type of establishment is not appropriate for a location immediately adjacent to homes. There are many other commercial zones in Fort Myers that could accommodate this type of business without impacting our residential neighborhood. For safety of our children, the protection of our property values, and the preservation of the quiet family environment that defines Hendry Creek Drive, we respectfully urge you to deny this liquor license request. Thank you.
Thank you for coming today. The next card I have is for Linda Parks. Good afternoon.
Good afternoon. Linda Parks, 7010 Hendry Creek Drive. I'm their next door neighbor. I directly see the property in question. I believe it's a misuse of agricultural classification due to the fact that there is not any agricultural going on at the property. There's also insufficient event controls. The guest capacity parking is totally inadequate. There are not that many spaces and there's no other place to park. The noise is not going to be held back by a wall. It's like a tissue paper. Useless. There's no security. There's a lack of security. There's a substantial degradation to the environment. The creek is right next door to the pole barn. There's a substantial off-site impact. It could be underage drinking, public intoxication, disorderly conduct, driving under the influence, which poses a threat to the neighborhood. This is incompatible with the surrounding neighborhood. There's an increase of traffic. There's an increase of noise. It substantially interferes with the use and enjoyment of my land and use. And these alcohol-fueled events are the primary use of the property, which supersedes any legitimate agricultural classification. There's nothing going on there agricultural. This is a hardship brought on by the people who purposely designed and built that building for alcohol-fueled events, knowing they would have to get some kind of a dispensation. Thank you.
Thank you for coming today. I believe all the other cards I had were from the last hearing. Richard McConville was the only other card. No. Okay. Did the applicant need more time before we go back to rebuttal or closing comments?
10 minutes.
10 minutes? Okay, we'll take a 10-minute break and reconvene at 2:25. Okay, we are back on the record and we can begin with the applicant's rebuttal whenever you're ready.
Again, for the record, Patrick Murray with RBI Planning. No necessarily of a rebuttal to any of public comments. I do want to go on the record though and clarify that when we discussed parking and we have the 83 parking spaces striped and then the remaining 4, there is plenty of space to accommodate that. It is a 10-acre site, and I also want to note that the 2 properties across the street are also owned by Mr. and Mrs. Bartley.
You did
Yep,
show me that on the map?
absolutely, yep. And this kind of notes, it is, yep. So there's the event center, the pole barn, and then these 2 properties here. Which brings me to the 5.1.5 consistency policy, as noted in the staff report, that the properties along Hendry Creek Drive frontage to include a additional buffer for those properties across Hendry Creek Drive. They are the actual property owners across Hendry Creek Drives themselves. With that, the applicant is requesting additional time to leave the record open for approximately a week to consider or submit the 4 new conditions, which would be type A plantings along the northern boundary, similar or mimic the western boundary, so the 4 trees per 100 feet. And then also to cap the attendees at 178 attendees. And then also maintain an agricultural exemption. And then prohibit the restaurant uses, specifically group 1 through 4.
You covered most of the notes that I had on here. The only other condition that I would like to see that we've done on other COPs for special exceptions of this nature would be exactly what you said at the outset, which was that any overflow parking that's not accommodated would need to be accommodated on site. It sounds like you've got the capacity to do that, but just to have a condition that reinforces that. And I believe otherwise you addressed the other notes I had. Thank you.
And our intent regarding the type A buffer and type A plantings is that it's the Land Development Code, section 10.421A2 requires 1/2 of the required planting buffer distance. So our intent is to meet that requirement and include those type A plantings.
So you would do the plantings within a truncated width area? What is the actual, I guess, deviation, for lack of a better word, that would need to be accommodated to provide the buffer that the staff is requesting?
So right now, between the back of, and this is specifically on the western side, back of curb to the property line is 5 feet. That in between there includes the wall and the tree plantings themselves. So we have 2.5 feet is where we have, and 5 feet is the requirement.
And they said that they believe that you met that on the western side, but on the northern side seems to be where the rub is. So what is provided on the north? You have the wall, but no plantings?
Correct, and our applicant is open to including that as a condition to add those plantings.
Could you accommodate the full plantings that are required under?
I believe we are restricted on space between the wall, and that may require the relocation of the wall and itself.
So what is and again, it's confusing, right? So because in your 48-hour letter, you took great issue and objected to the fact that that wasn't a condition that was there before, which I understand you just don't like that it's new, but is there a way to accommodate it, or are you physically cannot accommodate it on the site, was my understanding?
Physically, we cannot accommodate it as it stands in section 10.421A2.
Because you don't have sufficient width.
Correct. But we are open to meeting the intent and adding that additional condition to meet the type A plantings.
Okay, so you would plant within a truncated width area,
Yes.
but still meet the type A? Okay,
Yes.
thank you for that clarification.
And again, just allow us a week to wordsmith that and work with staff on the conditions themselves. Thank you.
Is there anything further for rebuttal from the applicant?
No, just to reiterate, we want to have the limitation on hours of operation to be what was proposed previously, in part in exchange for those additional conditions.
And staff?
Again, for the record, Cam Mohammed, zoning planner with Lee County's DCD. First point that I would like to address would be the max occupants. Within the zoning regulation, there is actually no way to enforce a maximum occupancy. Building permits and other building aspects do list maximum occupants, but from my standpoint in zoning, I don't have a way to enforce the maximum occupants. So
Is the 83 spaces that they provided consistent with Chapter 34 zoning requirements? They put testimony on the record,
right.
but that wasn't in the record, so I want to know what.
Yes, from my calculation, yes, based on the amount of square footage that's going to be used for the COP areas between the two buildings, or the pole barn and the actual event center. The calculation between the pole barn and the event center, the amount of square footage, that calculation does derive 83, and based on what they're providing, I think there's an additional 4 spots that may be provided. Second, I would like to speak on the hours of operation, and specifically, I conducted some research regarding previous consumption on premises approvals in conjunction with limited food and beverage, and I have record of a specific special exception, Southern Fresh Farms. I would like to.
Thank you. And what were the hours imposed in this case?
Is
So
there a
the-
copy for me?
Yep, give me just a second. So COP hours of operations are detailed here as Thursday through Saturday, COP 12 p.m. until 9 p.m. and Sunday COP 12 p.m. until 6 p.m. So this case in particular, which is most similar to what we're looking at currently, actually provides more restrictive hours of operations than what has been currently proposed in the conditions for this case. There are 4 other cases that have special exceptions for COP that also have varying times for consumption on premises, and essentially they're all quite varying times, but the majority of those cases are a lot more restrictive than what's been proposed today. The applicant did mention that they are in favor of a condition that states that they will not be performing as a restaurant, group 1 through 4. I would like to share the definitions of the licensing and illustrate the difference between 4 COP SFS as well as 4 COP quota. 4 COP SFS permits beer, wine, and liquor to be sold by the drink for consumption on premises or in a sealed container meeting the requirements of State Statute 561-22A4 for consumption off premises. A 4 COP SFS license holder must have 2,000 square feet of service area, be equipped to serve meals to 120 persons at one time, has at least 120 physical seats available for patrons to use during operating hours, holds itself out as a restaurant, and derives at least 51% of gross food and beverage revenue from the sale of food and non-alcoholic beverages, may not operate as a package store, and may not sell intoxicating beverages after the hours of serving or consumption of food has elapsed. License holders may not operate as a package store and may not sell intoxicating beverages after the hours of serving or consumption of food have elapsed. License may not be moved to a new location. 4 COP quota, defined as, or it allows for the sale of beer, wine, and liquor by the drink or in sealed containers for consumption on or off the premises where sold. A 4 COP quota license holder must maintain the licensed premises in an active manner in which the licensed premises are open for business to the public for the bona fide retail sale of authorized alcoholic beverages during regular and reasonable business hours for the minimum hours per day and days per year as specified in the statute 561-29H or I as applicable to the license. So based on these licenses, there must be some sort of decision made by the applicant as to which license is sought. And based on their recommendation of a condition to restrict them from any possibility of acting as if they were a restaurant, a 4COP quota license seems to be the only fitting license.
Wait, walk me through what you just said, because it sounds like, I thought what you were trying to put into the record is that a 4COP SFS has that nomenclature that it holds itself out as a restaurant. So I thought
Right.
you were saying that it would be incongruent to approve them for a 4COP while at the same time conditioning them that they cannot be a restaurant.
Right.
But how does that relate to the quota?
So the quota doesn't specify anything regarding the amount of sales for what would be required non-alcoholic beverage sales or the revenue from such.
Okay, so you would still approve them for a 4COP, but you would remove the SFS
Exactly.
rider, essentially. Okay. Thank you.
And that is all staff has for rebuttal.
What is can you explain for me maybe the nuance of how all of these things interrelate? You quoted ordinance, I think it's 1511. I'm not finding it in front of me, although I certainly have it. Because there's the identified use as food and beverage service limited, I believe. So is that where you're getting the foothold for the restaurant
Yes, ma'am.
kind of use? So they would still fall within that, under your professional opinion?
So that ordinance allows for agritourism to hold that specific type of use or in conjunction with agritourism.
Correct, okay, thank you. Just wanted to be sure I understood that. Was there I'm sorry, Cam, was there anything that you wanted to put on the record with respect to the plantings on that northern boundary?
I would have to defer to an environmental plan.
Okay, thank you.
I would like to put something into the record because I've been watching the hearing. My name is Beth Workman. I'm a principal planner in the zoning section. The applicant read a section of the code 10421A2 into the record, but did not complete that code section. The end of that sentence says that no buffer must be less than 5 feet. So if what we're driving at is a buffer that's less than 5 feet, then we are not a type A buffer. We are going to be some other type of enhanced buffer to go with this existing wall to recognize compatibility. So that would have to be worked on. I just wanted to make that clear because that code is specifically, it says that you can overlap, but you can't have a buffer that's less than 5 feet. So if we're calling out a buffer that is 2 feet to put these plants in, that doesn't meet that code section. So we could call out a 2-foot plantable area as a 2-foot plantable area. It's not gonna kill the project, but we just gotta call a spade to meet that code section, because you just kind of read the beginning and then left off the back end. That's all I wanted to add into the record.
Okay, so there would still be some room, I guess.
There's some wiggle room. I don't know if it'll be trees or shrubs. That's something that they'll have to decide on with what we bring. I think the record's going to be left open to work on that, if I heard correctly. Okay.
Yes, with an eye towards attenuation. I mean, that's really the whole point, right? Is a visual screening aspect. You've accomplished that to some extent with the wall, but it's really the noise attenuation concern that the neighbors have that we're trying to protect as an offsite impact under the Florida statutes to still get to that. So just as you're working through this, whatever plantings those may be, I would like to see something jointly worked out, if you can agree on what it is, presented to me as a proposed condition. And if you can't agree, if there's alternatives that you're each willing to get to, I would like to see that as well, because it is final with me. It's not going to the board, so this is the shot that we have to try to protect everybody as best we can.
Yes, thank you. That's why I wanted to put it on the record, because
Thank you.
it does stop here.
Okay, I appreciate that. Was there anything else that staff had to put on the record? No? Okay. Okay, so then we will leave the record open. I'm going to provide 2 weeks. If you don't need it, that's great. You can always present it sooner, but you may have more work ahead of you than what you might think, so I just want to give time for that. That would be until end of business on October 24th. And again, the laundry list essentially of the conditions that were identified in what you just said, and as well providing for all of the on-site parking for any of the events. Thank you. Thank you, everyone, for coming. For those that spoke, you will receive a copy of the decision once it's released, and I appreciate everyone coming today. Thank you.
Thank you.